I thank Professor Van Loo for his statement. I now give the floor to Professor John Dugard. You have the floor, sir.
Mr. President, distinguished members of the Court, it is a privilege to be before you on behalf of the Republic of South Africa. In my speech today, I will briefly address the subject of jurisdiction and then examine the circumstances that give rise to our request for further provisional measures. In its order of 26 January of this year, the Court found that the applicant had prima facie established the existence of a dispute between it and the respondent relating to the application of the Genocide Convention, and that the Court had jurisdiction in terms of Article 9 of the Genocide Convention. In its order of 28 March, the Court found that there was no reason to revisit this decision. It is submitted that this conclusion remains valid for the present proceedings. The Court also found that Palestinians in the Gaza Strip have a plausible right to be protected from acts of genocide, and that South Africa had the right to seek compliance with this obligation. Again, the Court declared that this finding need not be revisited in its decision of 28 March. Again, it is submitted that this conclusion remains valid. The Court has found that South Africa has advanced a plausible genocide claim. On 26 January, the Court found that the situation in Gaza was one that required urgent attention and that there was a risk of irreparable prejudice. This was confirmed in the order of 28 March, and it is a situation that continues today. Indeed, it is further heightened now in the context of Israel's brutal attacks on Rafah and subsequent intensified bombing across the north and middle areas of Gaza. Mr. President, on the basis of the above findings, the Court ordered a number of provisional measures on 26 January. On 28 March, the Court found that the circumstances of the situation had changed in terms of Article 76 of the Rules of Court as a result of the risk of famine, and ordered 3 more provisional measures against Israel. Today, Mr. President, South Africa approaches the Court for a new provisional measures to ensure that the rights in issue in the proceedings, including the right of Palestinians to be protected from acts of genocide, will be protected. The rules of court allow the Court to order new provisional measures when new facts are established or there has been some change in the situation which justifies modification of the existing orders. It is, of course, impossible to provide an absolute definition of new facts or change in the situation, as it is necessary to have regard to the situation in each and every case. Decisions of the Court involving provisional measures have dealt with a change in the situation arising from new facts in completely different circumstances. Cases have dealt with matters of life and death, territorial change, and freedom of movement. Each case depends upon its own set of facts, and whether these facts have so altered the situation that new provisional measures are justified on the part of the Court. In issuing its March order, the Court considered that developments since January 2024, which it found to be exceptionally grave, constituted a change in the situation within the meaning of Article 76 of the Rules of Court. It also found that the previous provisional measures that it had indicated would not fully address the consequences arising from the changes in the situation. And this led the court to order further provisional measures. The changes in the situation since March of this year are in many ways graver still. They too justify the indication of further provisional measures. On 26 January this year, this court found that there was a catastrophic humanitarian situation in the Gaza Strip, which was at serious risk of deteriorating further before the court renders its final judgment, and this warranted provisional measures. On 28 March, the court found that the catastrophic living conditions of the Palestinians in the Gaza Strip have deteriorated further, in particular in view of the prolonged and widespread deprivation of food and other basic necessities. Mr. President, members of the court, it is difficult to imagine that the situation could get worse, but unfortunately it has. In the early days of the Gaza war, Israel forced Palestinians to relocate to the south, to the Rafah Governorate. 1.5 million people were crammed into this inhospitable area in the Rafah Governorate, which appeared to offer safety from Israel's bombing, artillery fire, and the brutality of its forces, influenced by genocidal incitement by its leaders. World leaders warned that an assault on Gaza, and in particular on Rafah, resulting in the forced and arbitrary evacuation of the already displaced Palestinians to even less hospitable parts of Gaza without adequate food, water, shelter, and hospitals would have disastrous consequences. The Director General of the World Health Organization declared that a military incursion into Rafah will plunge the crisis into unprecedented levels of humanitarian need. A ceasefire is needed for the sake of humanity. Israel, Mr. President, has not heeded this warning. It has not even fulfilled its own undertaking not to embark on an assault on Rafah without a proper evacuation plan. Instead, it has gone ahead and embarked on an attack on Rafah. The Rafah Governorate has been bombed, subjected to artillery fire and ground incursions. The Rafah crossing is closed, and the Kerem Shalom crossing is mostly disabled. Mr. President, my colleagues will provide you with a full account of Israel's genocidal acts in the Gaza Strip. It is my task to briefly indicate the new facts required by Article 75(3) and the change in the situation required by Article 76(1). Mr. President, this application for further provisional measures is prompted by Israel's assault on Rafah. It is this assault that constitutes the new facts, the change in circumstances. Rafah is the last refuge in Gaza for 1.5 million Palestinians, the majority of whom have been forcibly displaced from north and central Gaza. Rafah is the last viable part of Gaza for rehabilitation, public administration, the provision of basic services, and medical care. Israel has now commenced its long-threatened assault on Rafah. It has ordered the evacuation of Palestinians in Rafah to the barren sand dunes of Al-Mawasi. It has closed critical border crossings to humanitarian aid, medical supplies, goods and fuel, upon which the population of Rafah depends. Displacement, famine, and suffering are now the lot of the Palestinian group. Israel's actions are in violation of fundamental rules of humanitarian law, but in addition, they provide evidence of the crime of genocide in terms of Articles 2, A, B, C, and D of the Genocide Convention. Mr. President, members of the Court, this attack is the final blow that is intended to destroy the Palestinian group in Gaza. That this is the intention of the final operation will be made clear by Mr. Nkwakhobi. Mr. President, since South Africa filed the present application for provisional measures, Israel has intensified its offensive in the north and in central Gaza. In these circumstances, we have requested the Court to issue a provisional measure that orders Israel to cease its military activities throughout Gaza and to withdraw from the territory. Such an order alone can bring an end to Israel's genocide in Gaza. That the Court has the power to order such a provisional measure is clear. The Court has stated that in terms of Article 75(2) of the Rules of Court, it has the power under its statute, when a request for provisional measures has been made, to indicate provisional measures that are in whole or in part other than those requested. Mr. President, members of the Court, this concludes my speech. I thank you for your attention.